Okay, for the second part, I would like to turn over the program to Professor Kenneth Gormley. Professor Kenneth Gormley, as was previously introduced by Professor Barrett, is from Duquesne Law School. Professor Gormley.
Thank you. We're now going to switch to the segment where we discuss the Steele seizure case. And for those of you in the audience who aren't familiar with it, let me just give you this much background. In April of 1952, President Harry Truman made a decision that would forever haunt his presidency. The steel companies and the steel workers' unions were at an impasse. There was about to be a strike of over 600,000 steel workers, which President Truman feared would cripple production of steel necessary for efforts in the Korean War. And so President Truman made a bold decision. He ordered his Secretary of Commerce, Charles Sawyer, to seize the nation's steel mills to keep them running. And in an address on April 8th, he said, "Our national security and our chances of peace depend on our defense production, and our defense production depend on steel." The response to this action by President Truman was swift and negative. The Chicago Daily News called this leaping socialism. The New York Daily News said Hitler and Mussolini would have loved this. The Washington Post wrote, "President Truman's seizure of the steel industry will probably go down in history as one of the most high-handed acts committed by an American president." The United States Supreme Court swiftly granted certiorari in this case, actually in record speed, and concluded that President Truman had exceeded his powers under the Constitution. This definitive 6-3 decision in the Youngstown Sheet and Tube versus Sawyer case amounted to a stern rebuke of President Truman at the end of his presidency, and it also became, really, I always say, the granddaddy of the cases dealing with presidential power. That is the granddaddy of the cases dealing with presidential power that is still relevant today. In 2002, I had the privilege of organizing a program co-hosted by Duquesne University and the Truman Library and Institute, bringing together, celebrating the 50th anniversary of this case and bringing together many of the people involved in it. But as part of that program, Chief Justice William H. Rehnquist, who was a co-clerk of these gentlemen, a clerk for Justice Robert Jackson on the Supreme Court as a young man, was gracious enough to agree to a filmed interview to begin that program. And so likewise, I thought it was fitting today that we should begin this segment of the program with this brief filmed interview by the late Chief Justice Rehnquist. Good afternoon, Chief Justice Rehnquist. On behalf of everyone assembled at Duquesne University in Pittsburgh, as well as the Harry S. Truman Presidential Museum and Library that's co-sponsoring this event, I'd like to thank you for participating in this special program. I have just a few questions to set the stage as we begin this retrospective, looking back 50 years in history. You were just a 27-year-old law clerk, clerking for Justice Jackson, only a few months in Washington at the time the steel seizure case landed in the courts. At the time, was this a case everyone expected would be a constitutional landmark? What was the atmosphere surrounding it?
The atmosphere, so far as one living in Washington was concerned, was very much that it would. The law clerks talked about it at lunch, and it wasn't just the Supreme Court arguments in the case that received press coverage. The arguments before Judge Pine in the district court were front page news in the Washington papers, perhaps not elsewhere.
And did you and your fellow law clerks have any prediction what would be the final outcome when it worked its way through the Supreme Court?
Oh, I don't think most of us knew what position our justices would take. We did have a vote at lunch one day, and I think, as I recall, we were evenly divided, but that was not on the basis of what we thought our justices would do, because most of us didn't know.
And what do you remember most vividly about the oral argument? I believe it was May 12th of 1952.
Well, the fact that John W. Davis argued for over an hour and I think was asked only one question. I mean, he had a style of advocacy that you don't hear nowadays, but it was very impressive. And then Solicitor General Perlman got a whole bunch of questions from the court.
And Arthur Goldberg participated as well?
Yes, he participated in oral argument for the AFL-CIO, I believe.
For the steelworkers, yes. And in your book on the Supreme Court, you tell a wonderful story about the Justices' Conference that Friday, at which they voted on the case in private. What do you remember about that?
Well, as I say, of course, the clerks weren't present at the conference, but George Niebank, my co-clerk, and I were just as dying to find out what happened, as I suspect all the other clerks were too. So we followed Justice Jackson into his office when he got back, just as we always did, and he would tell us what happened at the conference. And he said, "Well, boys, the president got licked."
And Justice Jackson's concurring opinion in the Steele seizure case is generally regarded by constitutional scholars as the most significant. What did he say about presidential powers, and why did he write separately?
Well, I think he wrote separately because almost everybody did write separately. I think the opinions had to be prepared in a fairly short time, and I think even those who agreed with Justice Black's outcome felt that there needed to be more said about the thing. And Justice Jackson's concurring opinion classified presidential power in three different ways. First, where he was acting with the approval of Congress, and there Jackson said, only if the whole government is disabled does he lose. Second, where he's acting without congressional authorization, but without congressional disapproval, and there it's kind of a middle ground. And finally, what Jackson felt had happened in the Steele seizure case, where he was acting in an area where Congress said, don't do what you want to do something else. And there he said the power is at its nadir.
Right. And did public opinion, do you think, influence the court's ultimate decision that President Truman had exceeded his constitutional power?
I think it did. The government made some extraordinary claims at the very beginning in the district court that the president had all the authority that George III had unless it was taken from him by the Constitution. Well, you can imagine the press outcry about this. I mean, it just made headlines. And it just gave a negative aspect. The government abandoned that argument long before it got to the Supreme Court, but it just got the government off on the wrong foot.
And there was an ambivalence about the Korean War even at that point, wasn't there?
Very much so. There were people fighting and dying in Korea, but very few sacrifices called for on the home front. World War II, I'm not that old. World War II, you had 14 million people under arms, but a lot of things restricted on the home front. The Korean War, you just didn't have those restrictions on the home front, so there was just a real ambivalence, as you say.
Yes. And what would you say is the lasting significance of the Steele seizure case as we look back in constitutional history 50 years?
Well, I think the subsequent opinions of the court have adopted Justice Jackson's concurrence, and that kind of trifurcation is probably its contribution. I think people have expressed the view that had it come up in time of declared war, it might have come out differently. And so, it's just one of many cases in this area, but I think the Jackson concurrence has been pretty much what it stood for.
And I'm reminded that one of the great things about a retrospective like this is it allows us to learn history from key people who actually participated in it. So your recollections are particularly relevant and meaningful, and it puts us in a good position now to step back a half century and examine a presidential decision that's really largely been lost to history books and law books, but is still highly relevant. So thank you very much, Chief Justice Rehnquist, for introducing today's program.
It's been a pleasure to be here, Professor Gormley.
Thank you very much. I think you can get a sense even from that brief recap by Chief Justice Rehnquist how monumental this decision was at the time. And so we're now fortunate to have with us 5 other law clerks from the Supreme Court term of that year to discuss the significance of the Steele seizure case that was important then, and also, as we'll discuss, is important even today with respect to the whole issue of presidential power. So I want to start with Jim Paul and Abner Mikva and just ask for your recollections. Chief Justice Rehnquist talked about the argument with John W. Davis, famous Supreme Court lawyer, once candidate for president, and Arthur Goldberg, later on the Supreme Court representing the unions. What do you remember about it, Jim?
Well, I remember John W. Davis because I suppose for an older generation he was really a role model. I mean, after all, here was a man who had run for president, I'm told, and of course he lost miserably, but he campaigned with dignity, and then had been Solicitor General and held many other public positions, and was sort of dean of the bar, and was also earning a hell of a lot of money on Wall Street. And he made, as Bill Rehnquist said, a very impressive argument. I'm not sure whether he got one question or no questions, but obviously the justices were reluctant on that score. And what I remember most is his dramatic finish. And he got up and, or he was up on his feet, and he said, "Trust no man with power, but bind him down with the chains of the Constitution." And he pulled out a big handkerchief, which I don't have, and dabbed his eyes with it, and sat down. And one thing more, I may be wrong on this, but I was looking at the Chief Justice, my boss, and his mouth seemed to be making some words. I figured he was making two one-syllable words, two different one-syllable words. You can guess what they might have been.
Well, you have to remember, we were all in our mid-20s, and our recollections now were probably somewhat reshaped and restructured, but then they were never tempered by judgment. At least mine weren't. I thought I knew it, and I could tell what my eyes saw and my ears heard. And I saw this very crotchety old gentleman. He had to be at least 70 years old. Way over the hill, making this argument. I could barely hear him sitting off on the side there. And the court was very respectful, like saying, well, but they're not paying any attention to the important question. They're just revering his age and revering the things he has done in the past, but he's really much too old to make this important an argument. 70, my goodness. And on the other hand, the Solicitor General Perlman, who, as I recall, was second, I think Arthur Goldberg argued last, at least that's the way I remember it. Perlman got up, and he was a very forceful, vigorous Solicitor General, but he was very troubled by the question. I had a feeling that he really didn't have his heart set on what President Truman wanted to do. And it was more like a professorial lecture, except with a lot of hand-waving about, well, on the one hand, on the other hand. And he just didn't seem forceful enough about it. And Arthur Goldberg, who was given, as I recall, 5 minutes of argument compared to John W. Davis's hour and Perlman's whatever, Arthur Goldberg was arguing on behalf of the steelworkers, and he was then way in his prime. He was in his early 40s or late 30s. And he bounced up there with vigor, and he, in 5 minutes, it seemed to me, laid out exactly why President Truman's position ought to be upheld, which is where my boss was anyway. And I became so enamored with Goldberg's argument that I made up my mind right then and there that I wanted to work for him, and I did.
And Neil Rutledge, you clerked for Justice Black, who actually wrote the majority opinion, although Justice Jackson's opinion, as we heard in the video, is considered the most famous today. Did you talk to Justice Black about your views on this case?
Yes, this case zoomed up at the end of the term. It went before the district court. The district court enjoined the seizure. The U.S. Court of Appeals stayed that injunction, but they didn't have a chance to actually hear full oral argument or to decide anything more in the case. And then the Supreme Court granted cert right away. So it came up in a matter of weeks, and everybody knew that it was a very important case. It was going to be extremely important. We were at war. I know that we were at war because a very good friend of mine got shot and lost his right leg within months of this happening over in Korea. We were fighting a war. We were as much at a war then as we are now. Anyway, I think the clerks particularly were aware of this. Anyway, the case came up and was decided by the court, and I'm not sure, it may have been Justice Jackson who described Black's opinion for the majority as the lowest common denominator. And it was that. This was a constitutional issue that came up very fast, and almost every judge that considered the case, I'm not sure whether there were 9 opinions, but there certainly were 7 or 8 different opinions. And Black wrote the majority opinion, and one reason it is the majority opinion is because, and the audience may not realize this, but if the Chief Justice, when they vote on a case, is in the majority, he decides who will write the opinion for the court. He may assign it to himself, or he may assign it to any of the other judges who are voting with the majority. If he's in the dissent, as he was in this case, then the next senior justice takes on that role. Well, Black was the next senior justice.
Right, and just tell us briefly, Neil, what were the salient points of his position? Why is it that he concluded that President Truman had exceeded his powers?
Exactly, and he concluded that Congress had acted in this area repeatedly, that there were basically 3 statutes. The Taft-Hartley Act was one of them, the Selective Service Act had a provision, and the
Defense Production Act.
The Defense Production Act. All had provisions that applied, at least in part, to this kind of a problem. And none of them provided for the kind of a seizure that Truman had done. And so Black, who had served in the United States Senate for many years, and who had great deference for the legislative power of Congress, and it was his feeling, I disagreed with him, argued with him, it was his feeling that since Congress had acted in this, that the president had to follow whatever Congress had prescribed. And he wrote, here is this book contains all the decision from the terms that we served for this 51 term, and the decision in this case consumes about 100 pages here.
It's 131 pages long plus an appendix.
Exactly. And Black's majority opinion for the court, which at least 6 people did concur in, is about 3 or 4 pages long.
Right.
So it was a very brief, simply saying the president, he does not have any congressional power. Moreover, Congress has acted in this field. He has acted contrary to what Congress has prescribed. He therefore has acted beyond the powers that he enjoys in this.
And let me ask Marshall Small, you clerked for Justice Douglas, who was also in the majority. This case, as we mentioned, came up very rapidly through the courts. How did that impact just the way this was handled in the courts and by the government?
Well, the government did not really have much time to prepare its briefs, and I have to think that that had some effect on the court. There was one decision, the Midwest oil case, that Felix Frankfurter presented to John W. Davis in an argument that would have been in the government's favor, and that Davis had actually argued as Solicitor General back in 1915, I think, and said, well, now you're arguing the opposite. The government didn't have that case in its brief, and whether it took Davis by surprise or not, he handled it very gracefully in trying to explain it away, which I think was a testament to his abilities as an appellate advocate. But I think it underscored the fact that the government had not taken the time, and maybe didn't have the time, to carefully consider the nuances involved in determining, what kind of powers should a president have in this kind of setting. They really took a rather meat-axe approach that, he had whatever power he needed, and I think that bothered the justices. The conference notes of their discussions of the case after oral argument tend to underscore some of that they were concerned with the position that the government had taken, and for that reason felt they needed to do something to respond to it. They might have, under some circumstances, tried to avoid taking the case at all. There was some argument for them not even taking the case, but because the president's power had been put forth in such bold fashion, I suspect they felt they needed to do something to respond.
And it wasn't simply a question of how the government presented the case, was it? I mean, Harry Truman hated the Taft-Hartley Act. It was anathema to the unions, and so he was not going to use it even though he had it available. And you had the fact that he was at the rock bottom of popularity at that point.
All that was true, and I think that probably also had something to do with the court's approach. That here, the Congress had said, here's an approach you could take. You don't need to use uncharted presidential power, and therefore used Taft-Hartley. As you say, he had vetoed Taft-Hartley. He didn't want to use it. And interesting aftermath, when the court came down and said, sorry, you were wrong, and he then asked Congress to give him authority without having to use Taft-Hartley, and Congress came back and said, no, use Taft-Hartley after the court's decision, and he still refused to use Taft-Hartley, and finally he was able to, I think, work out an agreement between the union and the steel companies so that by the end of July of '52, the potential strike was settled, and therefore they could move on about their business. But that was the other aspect of this case, which was a combination of politics in terms of his view of Taft-Hartley, his lack of approval rating in the country. I think at the time he had about the lowest approval rating of any president of that generation.
Right. And President Truman was indeed planning to go in and ask for permission after Congress. It reminds me of when I asked my future father-in-law, for my wife's hand in marriage after she had already said yes. He said, it sounds like the horse is already out of the barn or whatever. But I think the idea was, if you're going to do this, you have to do beforehand and actually get Congress's approval. I want to talk about the dissents in a minute, but first, Charlie Howman, because you clerked for Justice Burton, who was one of the Truman appointees on the court who voted against the president, and you just described the fact that he sat right beside him in the Senate. Do you think that this was a difficult thing for your boss, Justice Burton, to vote against the president who had appointed him?
Well, he not only sat beside him in the Senate for all those years, but they became personal friends, and they really were good friends. And I'm sure it was a tough problem for Justice Burton, but he never, I don't recall him ever saying anything to me about that. That is, that what am I going to do with my good friend Harry Truman? I have to vote against him. And so I'm sure it was hard to do, and I learned later that President Truman was very upset over the fact that Justice Burton had voted against him. And as a matter of fact, it was thought that if Burton had voted to support the president, then Justice Minton probably would have done the same. Minton did, but and Minton
Clark, Justice Clark.
Clark was also a Truman appointee. That the decision would have gone the other way.
And in the end, what do you think persuaded most from the opinion? What can we tell persuaded Justice Burton to vote as he did in support of against the president's power here?
Well, he said in his opinion that the Congress has the power would have had the power to do this, to authorize the president to do it, but Congress did not. And as a matter of fact, the legislative history of the Taft-Hartley Act showed that the question was proposed and that there be a provision in the Taft-Hartley Act authorizing the president to seize the property in the event of an emergency, and Congress voted it down. They wouldn't.
Right.
So in effect, he said, Congress says, you don't have the authority as the president to do this unless we say so. And Truman was a former senator, and he had great respect for the Senate, and he felt compelled to take that position and support what Justice Black said.
Right, and it becomes important in the Justice Jackson test, obviously, because this was a case where the president was acting against the express will of Congress, and that was very significant.
Truman also left the door, Burton left the door open for situations in which there'd be a really emergency situation. He said in his opinion that this might be different. It said the president had no power under the present circumstances. This is not comparable to the threat of imminent invasion or threatened attack or other catastrophe. So he intimated in his opinion maybe if this had been a declared war and that would have been different, or if he left the door open for more serious consequences.
Right. President Truman was asked by a journalist what in the Constitution gave him the authority to do this, to seize the steel mills, and his answer was, read the Constitution, it gives the president the power to keep the country from going to hell. So that was his foundation for his power. But let me ask the dissenters. Jim Paul, you clerked for Chief Justice Vinson, another probably the closest friend of President Truman on the court. The dissent's position was a little more sophisticated than that, I would think, that you had the power to keep the country from going to hell. What exactly was it that drove Chief Justice Vinson here in his very forceful dissent?
I'm sorry. The question
what was the logic behind his forceful dissent?
Well, it was a shared belief with, this is the basic premise on which the decision's laid, a shared belief with the president and I might say the president's cabinet, who all swore out affidavits supporting this position, eminent American statesmen, that cabinet. There was an emergency, and we couldn't do without steel in this conflict. Whether you call it a war or not seemed irrelevant. His second premise was that Congress had appropriated money to buy armaments and lots of other legislation to support this war, all with the support of the president, and that these were laws on the books, and they were active laws, they were there, they needed to be enforced, and therefore he did have the power, as that part of the Constitution that says the president shall exercise or enforce the laws, plural laws. The Vinson view was that's exactly what the president was. He was maintaining these laws, which were aimed at maintaining the strength of the American forces. And then, next point was, the president did go immediately to Congress. He presented Congress with a formal report saying, I've done this. I recognize power of Congress to alter my decision or repudiate it or leave it alone, whatever you want. But I felt compelled to do this in order to preserve the situation. This was not a decision or an opinion that says the president has great powers as commander-in-chief. It was not an opinion that says the president has inherent powers in wartime, whatever that means. Unlike the assertions that are made today in certain quarters in Washington, this was not that expansive. It was, I did this in a state of emergency, but Congress has the final say on it. Recognition of the jurisdiction of Congress. Finally, I don't think the court, for all the opinions, that issue was really joined with the Chief Justice on that. I admire Jackson's concurring opinion. It's particularly law professors would love it. But Jackson never really got to the point of confronting Vinson's argument. Finally, one other point as to this failure, this dismal failure of the Truman appointees, Justice Burton and Justice Clark, to let him down. And I wish our good friend Stu Sayre, who was clerk for Clark, is here. Unfortunately, he's no longer with us. But Truman did say some things about this sad situation. He told Fred Vinson, I wish I'd never appointed that son of a bitch to the court. It was the worst mistake I ever made. Justice Black asked Truman and some of the other justices to a small party right after the decision. Black felt he owed it to Truman to do this, mark a gesture of respect. Truman went. He was a little grouchy when the thing started off. But then finally he said to Black, he said, Hugo, I don't like your law at all, but your bourbon's mighty good.
And Judge Mikva, you clerked for the other, one of the other dissenters, Justice Minton. What was it that made him feel so strongly about this case?
It's amazing how it's like 10 blind men each feeling a different piece of the elephant and deciding what the animal is. In my chambers, we never got into this business of the trifurcation of the power. As far as Shea Minton was concerned, this was a simple question of loyalty to the president. And I remember he didn't write. He said, whatever the chief says on this, I'm going to go along with, because as far as he was concerned, he and the chief were of a single mind, and that is that Truman had appointed them. Truman said he needed this power, and by God, they weren't going to take it away from him. If he thought it was important enough, he was in the position, and they were going to let him do it. A lot of things went into that. Part of it was this was a property matter. I don't know how they would have felt if it had been a liberty matter. Not that Minton was that sensitive to civil liberties, but he certainly would have been more sensitive than the fact that this was simply private property, and the president was saying it's important to carry on the war. Secondly, they recognized, and I even went back and read the dissent again, there was a little bit of difficulty about talking about this as a war, because the president had said it wasn't a war. It was a police action. We had never declared the Korean War. This was a UN action. And so the president, in issuing his proclamation in the first place, relied on a lot of World War II statutes, because technically we were still in a state of war with either Germany or Japan. I don't remember which. Japan. And that was a little far-fetched as a rationale for this importance of power, this seizure of power that he had exercised. And really, as far as Minton was concerned, this was not a matter that needed a lot of deep dissection. You looked at a president who had had a lot of trouble with the Congress, a lot of trouble in the country at that time. He said it was important. You were his friend. You went along.
And the threat of communism was very real.
And the threat of communism was real, and you don't tamper with his power in that kind of respect. I think it would have been a lot different if Harry Truman had been riding the crest of a high popularity wave of 70, 80% approval, because there are other actions. I remember Minton was, just going back to a little bit of history to remind us of other things that other presidents had done, way beyond this seizure of the steel mills without congressional approval, and had gotten away with it. Jefferson had bought a third of the United States with the Louisiana Purchase without getting Congress's approval.
And Lincoln during the Civil War.
Lincoln had kept the Maryland legislature physically from meeting because they were going to vote to secede from the Union, and he sent soldiers to keep the legislators from going to the Capitol building, and he got away with it. And at one point, when the Chief Justice issued some kind of a writ against Lincoln, he ignored it, and he got away with it. And and President Roosevelt during World War II had put all these Japanese Americans behind in prison camps, in concentration camps, detention camps they were called, and got away with it. And the Supreme Court ultimately upheld it. And so as far as Sherman Minton was concerned, here was this good and decent man who thought that the country needed the exercise of this power, and he was not going to be a part of taking it away.
And incidentally, some of the biographies in recent years have indicated that Chief Justice Vinson actually went over and consulted with, or President Truman consulted with him before making, or during the time he made the decision to seize the mills, and perhaps some communications with Justice Minton. Do you care to say anything about those stories?
Well, Minton was a part of that poker game that Jim Paul referred to, that he and the Chief Justice would go over to the White House and play poker with Harry Truman. I got the impression he really was quite indignant. I don't think he ever used the language about Harold Burton that the president used, but he was quite indignant about Burton and Clark leaving the ship that way. And I got the impression that he had been over at the White House playing poker one of these nights, whether it was before the decision, well, I know it was before the decision came down, whether it was before it was argued, before the mills were actually seized or not, I don't know. But he came back, he told us that he was very upset about, he and Vinson and the president were all very upset about the fact that Burton didn't understand how important this was to the president's maintaining his position to support him, and that if Burton had gone along, then clearly Clark would have gone along, and they would have had a majority.
And Ken Heckler, who was an advisor to President Truman, told me during the program years ago that there was blue smoke that you could see coming out of the White House after this decision, and he was particularly angry, according to Ken Heckler, at Justice Tom Clark. But those friends of his whom he had appointed, it clearly meant something. In terms of, and Marshall Small, you referred to these conference notes that you dug out from Justice Douglas, which are incredible. Actually, they talk about, they record that Justice Minton, I believe, was getting very excited and pounds on the table. He says the nation is at war, the men in Korea need the steel, and he was insistent on it. This was an extremely emotional topic for certain of the justices.
I think we should give credit to David Danowski, a retired professor at Stanford, whose writing has been working 10 years on a very objective biography of Justice Douglas, and he kindly went into his voluminous records and sent me the conference notes. Douglas had a habit of putting all things into the public record at the Library of Congress, so there's just all sorts of things there, and that's how we got these fascinating notes.
And a couple of questions before we start wrapping up. One that I think is significant, I want to see if you have any comments. David Feller, who was one of the lawyers who worked alongside Arthur Goldberg representing the unions, told me the story that the White House almost had this case, this matter settled between the steel workers and the steel companies, and it was only because the Supreme Court rushed in literally record-breaking time, granted cert, took the case. The minute that happened, the negotiations collapsed, and that was the end of it. Is this a case? Is this an historic case that the Supreme Court should have never taken?
David Feller was a partner of mine later on, and as was Arthur Goldberg, and I think that very much was a fact. The union and the companies had been negotiating, and even during the seizure there were negotiations continuing. If the case had taken its normal course, they probably would have reached a settlement. They were very close at the time the opinion came down. In fact, my co-clerk and I had this internal ethical battle that we knew that the case was coming down, and we also had heard from the grapevine that the parties were close to settling, and the question was, could one of us call Arthur Goldberg and tell him to quickly settle it because the court was going to go the other way? And we decided wisely, I think in retrospect, that was not a good idea.
That's why you still have your law license today.
That's why I still have my law license. Yes. But it might not be here today. But at the time, it really was a matter of timing. And there were a lot of scuttlebutt around the court even that that if the court had just taken the normal course of things, this whole constitutional dispute might have been avoided because the parties would have settled. I thought about that many times in the 2000 election when, all partisanship aside, it was clear that whether the court decided it or the Congress decided it, George Bush was going to be the next president of the United States. But it would have been the same way if the court had stayed its hand, as I was predicting it was going to do with all my assurance of that I would know what the court was going to do. It never occurred to me that the court would step in that quickly and make a decision, because clearly the political process was working, and the Congress would have made the same decision without the court using up its credentials.
And the other fascinating thing here is that the justices didn't disagree with the fact that there was an emergency here. And in fact, the conference notes that we referred to show that Justice Jackson says, we aren't here to quibble with the president when he makes a determination that there's an emergency. We assume that's true. And there were affidavits from the Secretary of Defense saying there was an emergency. But as Chief Justice Rehnquist said in that film, it didn't feel like an emergency to the country. And is it true that if there had been a real sense of emergency here, the Steele seizure case may have come out differently?
Only history can record, but I think as you look back on what happened in the nation's history, I think that might well have been the case. We only need to think about what happened during World War II with the Japanese internment situation. Clearly, there was perceived to be an emergency, wrongfully perceived as it turned out later, but as in so many of these cases, they're going to be decided in an arena where there is a perception that there is a felt need for something to be done to protect the security of the country.
I'd like to step in there. I think that's what Justice Burton said, been a true emergency, but I'd like to raise a different question, I'm sure isn't on your agenda. Marshall Small told us about Justice Douglas's conference notes. That's notes that the justice took during these secret conferences the justices had in deciding the cases. As far as I knew, that was sacrosanct. Nobody ever knew about that. And to see that they still exist and they can be found surprised me. And tell the group what you told us about Justice Black.
When Justice Black made, just as Justice Douglas did, he made very copious notes about what went on in the conference. And we were allowed, he kept those notes over in the Secretary's office. And of course, he was appointed back 37, I think it was. So he'd been on the court longer than anybody else there, and he had more of these notes. And all of the clerks had gone in and looked at his notes, which were superb. In fact, one of the outstanding things about my term as law clerk to Justice Black was that at midnight I was working there alone, and I had to go into the Secretary's office to get some of these conference notes. And I opened the door. I decided to go in through the judge's chambers because he wasn't there. I opened the door, turned on the lights, walked into the judge's chambers, and a shot rang out. And a bullet came in through the window, whizzed right through by my head, and went in. This was when within 2 weeks of Mrs. Black's death. So of course the Supreme Court police came up and investigated. They went out there, couldn't find who fired the shot. Immediately called Justice Black at his home to warn him somebody might be out after him. And he responded by enjoining the police, and he talked to me thoroughly and very sternly. He said, I don't want you to say a word about this to anybody. And he didn't want it to get out to hit the newspapers because he didn't want his wife to read about it, because she would then be even more worried, and he thought it might have an adverse effect.
About his deathbed.
Right. And then when he got on his own deathbed, and he had these wonderful notes, he called his son, Hugo Black Jr., called him in and said, in the interest of the confidentiality that I have kept on this I ask you to burn these notes. Instruct you to burn these notes. And very reluctantly, Hugo Jr. burned the notes in the fireplace there in the judge's chambers. And so I regret that very much, because they would have been wonderful.
Right, it's a loss to history.
That's
and
right.
let me, as we wrap up, let me just ask you to talk for a minute about the relevance of the Steele seizure case today, because I began by saying it's still the granddaddy of the cases dealing with presidential power. It's been cited in every major presidential power case, including U.S. v. Nixon, dealing with the Watergate tapes, Clinton v. Jones, dealing with the civil suit against President Clinton by Paula Jones. But in post 9/11 America, there have been lots of these presidential powers issues, as you know, dealing with the whole question of the Patriot Act, dealing with enemy combatants and the rights of enemy combatants, especially on American soil when they're U.S. citizens, and more recently having to do with President Bush's NSA secret surveillance wiretap program. All of these have raised presidential powers issues. What do you think the Steele seizure case, if anything, tells us about those questions?
Well, I think that Justice Jackson's concurring opinion continues to represent a kind of a compendium of when the president can act and when he shouldn't act, and when he needs congressional approval, and what he can do if it's different than what he wants to do. Today's New York Times, talk about the timeliness of this subject, has a long story about how the number 2 man in the Department of Justice tells about the Attorney General, then John Ashcroft, and several other people threatening to resign if President Bush didn't call off a secret wiretap program that was going on that went beyond the authority that Congress had given in one of the important pieces of legislation they'd passed. And in there they cite that the Attorney General, Ashcroft and others, were acting on the recommendations of a group known as the Office of Legal Counsel, a very important part of the Department of Justice. It's the think tank of justice. These are the bright lawyers, many of them career lawyers, who sit and ponder over cases and precedents. And I'm sure that if OLC, Office of Legal Counsel, wrote a memo to President Bush or to Attorney General Ashcroft, that in there cited many, many times would have been Justice Jackson's concurring opinion in Youngstown, Sheehan 2, and maybe even the majority and the minority, the dissent as well. But certainly Justice Jackson's opinion is continuing to set the parameters about which a president can and cannot act.
Right, and I can just tell the audience, I had the privilege of testifying in the Senate last year when the NSA wiretap program was first discovered, and half of the discussion in there was about the Steele seizure case and its relevance today, because if you heard Chief Justice Rehnquist talking about President Truman being at his low ebb of power because Congress hadn't authorized these steps, there's a strong argument that President Bush there had gone around what Congress had done with the FISA law, and in this case may have even been at a lower ebb than President Truman, because his actions came up against the rights of individual citizens, American citizens, under the Bill of Rights. Very much a discussion having to do with the Steele seizure case and its significance with respect to presidential power. The last thing I do want to just throw out for consideration, though, is that over the years discussing the Steele seizure case, there's no one here, is there, who thinks that President Truman took these steps out of some crazy desire to gather up power for himself. I mean, there's no disagreement, is there, that President Truman was acting because he thought this was necessary for the country. And likewise, President Bush, I sincerely believe, has taken steps because he thinks these are the right thing for the country. But that doesn't mean the Supreme Court doesn't do its job, and its clerks don't work to help the court do its job, so that it establishes the boundaries of presidential power. And that's really what this case is about, isn't it? The boundaries of presidential power.
Very seldom will the issue come up to the court, though. I think in the history of the country, where we've seen these sorts of exercise of presidential power in emergencies, very seldom has it been tested in the court, so it'll be very few cases, presumably, like the steel seizure case as we go forward and meet future emergencies.
Yeah, Jim.
I think we're wrapping up. It occurred to me that a quote from Justice Jackson in his much-cited opinion by Bill Rehnquist, Abner, and the rest of us, he said in there early on, I think, that these problems of defining the limits of presidential power, particularly by the court, are as strange and difficult as Joseph was confronted with when he was asked to interpret Pharaoh's dreams. That seems to me have some accuracy on it. I wouldn't have wanted to be Joseph in those days because Pharaoh's wrath might land you in a place you wouldn't want to be. But I don't think the decision supplies President Bush with much solace. Even the dissenting particularly. It's limited. The steel seizure case is very different from the kinds of presidential power asserted today. So we're left with doing Joseph's dream again.
Yeah, and I can't help, Justice Black was one of my favorite craftsmen on the court, and I can't help thinking back over the years when this issue has come up that what Justice Black wrote as his majority opinion in the steel seizure case was what Professor Cass Sunstein would call a minimalist opinion. He didn't reach any further than he needed to do, the lowest common denominator, to get the justices to go along with him. And therefore, as a precedent for what a president can or cannot do, it has its limitations. That's why the concurring opinion may be more useful as a scholarly pursuit. But in terms of how to decide a case, I think Justice Black did the minimum interference and harm in the way the government ought to work.
I agree with you absolutely on that.
Well, I want to say the main argument against the court's decision was that there was no need for the court to get into that serious constitutional issue. There were a lot of grounds on which it could have sent the case back for more evidence and so forth. And my own feeling is that the majority of the court felt that it was a time for the court to step in and to say what the limits of a president were. And I think that they were somewhat heroic in doing that.
And I'll turn this back over to John Barrett, but just by conclude by saying that in the end, it didn't hurt President Truman's legacy all that much, did it? And we now know after David McCullough's fine work on him and the popularity of President Truman today, that he did what he thought was necessary, the court did what it thought was necessary, and that's the beauty of our system.
And his coarse language makes him a solid, great guy, just like Andrew Jackson.
Right.
Thank you, Ken, and I know you will all join me in thanking the panelists. What we see here is really how 55 years is a blink, and how this country's big problems and big challenges are perpetual ones, involving, as we had in 1951, 1952, a great Supreme Court, a Supreme Court well served by extraordinarily talented law clerks. Our hope is at our time today we have a great Supreme Court served by extraordinary law clerks and an ability to grapple with the issues that challenge us in similar ways as these men and their bosses did in 1951, 1952. Please join me in thanking Marshall Small, Neil Rutledge, Charles Heilman, James Paul, and Abner Mikva, and Professor Ken Gormley.
Very good job.
Marshall, thank you. Superb. Really great. Neil, thanks.
You bet.
Well, I'm sorry we have to...
Charlie.
So much.